Welcome back, and we are live. Today's topic: what are the I-9 enforcement trends in 2025 and 2026? And we're going to go over a few cases that are actively being litigated so you can see what's actually happening on the ground. Welcome back to Immigration Compliance Corner. My name is Emily, and I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. We're a private law firm specializing in immigration compliance and federal litigation. We come live to you every Wednesday to go over the latest topics in immigration compliance, so I-9 and E-Verify, as well as the visa-specific compliance requirements. As always, before we get started, everything that I'm sharing today is general educational information only. It is not legal advice. Immigration law changes frequently, so for guidance tailored to your business, be sure to consult a qualified immigration attorney. So, just to set the scene, what's kind of been happening in 2025 and 2026, ICE conducted an estimated 12,000 to 15,000 I-9 audits in 2025. And this is 10 times more than the number of audits that they conducted in 2024. So there is a lot of different factors that could be driving this, including it's a state enforcement priority of the administration. On January 3rd, 2026, ICE announced that they had a 120% increase in their workforce, adding more than 12,000 officers and agents across the agency. And then the One Big Beautiful Bill Act separately funded 170 billion for enforcement with the addition of 10,000 officers. So it's looking like this might not just be a temporary surge, but they're trying to build a new permanent capacity in enforcement across the agency as a whole, which would also include I-9 compliance enforcement. Also, just for some background, if a company is audited by ICE for their I-9 records, you go through the whole process. At the end of it, ICE will then either give you a warning notice or a notice of intent to fine or some other notice of findings. If they issue a notice of intent to fine, you as the company can then actually challenge that in litigation. So you could file your complaint with the Office of the Chief Administrative Hearing Office, OCAHO, which is a section of EOIR, the Executive Office for Immigration Review, which are the administrative courts in immigration in DOJ. So it would actually be entire litigation if you wanted to challenge a notice of intent to fine. So today, what we're going to do is go through a few cases that are being actively litigated based on information that is available publicly online, what happened in those cases, the fines, and what this is telling us about ICE enforcement trends today. So the first case that I'm going to go over is a small restaurant. It is the case for El Sombrero. ICE alleged that Jorge Mata LLC, doing business as El Sombrero, failed to properly complete or timely prepare I-9s for 15 employees. So this is a small business, and only 15 employees were at issue here. However, ICE sought a fine of more than $36,000, which is pretty substantial for a small restaurant. That's about $2,432 per form for just a pure paperwork violation. There was no allegations that we can tell of for knowingly hiring unauthorized workers. So that's solely paperwork violations. Unfortunately, once the litigation started in this case, the employer stopped responding to the court's orders. So the judge did deem the case was abandoned and dismissed it. So that means that the employer is on the hook for the full more than $36,000 fine because that is now the final agency order from the administrative law judge. And the takeaway here, this employer didn't try to negotiate the fine down in the litigation. As far as we can tell, it went silent. So the entire number that ICE essentially assessed the fine for became final. And this was a really small employer who received fines without even any allegations of knowingly hiring unauthorized workers. So that's really significant. ICE isn't just going after companies who they think have unauthorized workers. Essentially, it is about the paperwork at the end of the day and whether or not the I-9 is being completed timely and properly. The second case we're going to discuss quickly is Dundee Water Park. Dundee Water Park LLC, doing business as Splash Universe Water Park Resort, failed to prepare or present I-9s for 10 employees, improperly completed I-9s for 18 employees, and then they did have an allegation of knowingly continuing to employ 3 unauthorized workers. So the fine at issue here was $61,136 for that amount of employees. This is a case that kind of shows the whole spectrum of how the fines can kind of start to multiply. So they first had missing forms, then they had forms that were not completed properly, and then they did have an allegation of knowingly hiring unauthorized workers, which can make the fines absolutely skyrocket or more than double. Unlike in the El Sombrero case, this employer is actively fighting it, and they're represented by counsel. They are responding to the court orders. But what's really important to notice in this case is that the court has scheduled discovery and a case timeline. So it seems, though, that the company is probably trying to make the argument that they're not knowingly hiring authorized workers, and that potentially opened it up to discovery. And so this just really emphasizes that you should be working with an attorney to ensure that your company's I-9 compliance program is solid. When you work with an attorney, you have the protection of attorney-client privilege for internal audits if the attorney is conducting the audit, and for anything that they're helping to build, any communications going back and forth over particular employees. When you have that relationship with an attorney, it's protected by attorney-client privilege, which means those communications and that work cannot be disclosed in litigation, such as a lawsuit here, where there's discovery. So it's really important to be working with an attorney, because there are discovery risks when it comes to I-9 compliance if you're audited and then you challenge that case in the administrative courts. Now, the third example is a case that has been more in the news, and it shows kind of like when ICE will do a sweep. So, what they can do is target a bunch of companies in the same industry in one particular region. So, this example is in Denver. There was a sweep of a bunch of different companies that had to relate to commercial cleaning and then property and facilities management. So this was a local market that they targeted at once, and the fines that came out of these different audits totaled more than $8 million. So one company was assessed a fine of over $6.2 million after a 100% substantive violation rate and evidence of knowingly employing at least 87 unauthorized workers. So huge. Commercial Cleaning Systems was another company, and they were fined almost 1.6 million for a 74% violation rate and knowingly employing at least 12 unauthorized workers. And then the third company was fined over about 270,000 for a 100% violation rate and identifying 44 unauthorized workers. So all three of them, they're all in the similar industry. They all have high turnover likely. It's probably subcontracted labor with a thin infrastructure. And those are profiles that ICE will like to go after when they know that there's probably holes in the pipeline. Also, the takeaway here is that ICE doesn't always audit one company at one time. When it decides to look at a sector in a metro area, it can hit several employers in the same sweep, and like they'll issue notices of inspection to companies all from like the same date. So it's literally like a batch audit that they'll do. Now, the last case I want to go over is to kind of show how even larger corporations with solid HR infrastructure are at risk for being fined. So, ICE is currently litigating a case against Brinker International Payroll Company, which is the parent company of Chili's Grill and Bar. So they're alleging that they failed to prepare or present I-9s for 6 employees, and that they failed to properly complete I-9s for 102 or more employees. They are represented by counsel, and the case is actively being litigated. The exact fine in this case has not been disclosed in the record yet, but if you take ICE's current fine range from $288 to $2,861, they could be on the hook for fines roughly from $31,000 to well over $290,000. And again, the key takeaway here is that this is a large company. It's Chili's parent company, and they probably have real HR infrastructure, probably doing electronic I-9s, I would imagine, real compliance budgets, and this is an active I-9 litigation. So any thoughts of like, oh, well, we're too big for this, that's not going to be a defense when it comes to I-9 compliance. So some of the takeaways of what's kind of happening with these I-9 compliance audits on the ground right now is that the industries are widening. There is more of a larger enforcement push, and we can kind of talk about why. So some of the top industries that do get audited by ICE are restaurants, construction, agricultural, grocery and retail stores, manufacturing, staffing, hospitality, food production. But if you're thinking, well, we're not hiring unauthorized workers, so this isn't going to be a problem, or I'm not in those industries, so this doesn't apply to me, that's not necessarily the right takeaway, especially how enforcement is starting to change. So, first, when you look at all of these cases, you have to see what they actually got in trouble for. And it's missing forms, a late section 2, incomplete records. That's not an industry specific problem. That's going to be a fast growth and decentralized hiring process problem. And any employer in the US that hires employees can be audited by ICE. So it's regardless of size and regardless of industry. And as I mentioned, the enforcement is changing. So there's more data now being shared between ICE and the IRS, and that could lead to potential I-9 audits. And then also, as I discussed last week, DOL is increasing their enforcement related to H-1B compliance. So that could also then lead to more cooperation and data sharing with ICE, especially for larger companies that are relying on H-1B workers or certain industries that rely on H-1B workers, like in the tech industry. If those industries are starting to be audited more by DOL, it could lead to data sharing that also then leads for more enforcement in the I-9 space from ICE. At the end of the day, it's your paperwork that's going to be your protection, not the industry that you're working in. And it's really important. Make sure you're working with an attorney at some point in the process so certain things can be protected by attorney client privilege. So even if you don't have an attorney do an audit every single year, make sure they're doing a full audit, every couple of years to make sure that your I-9s are in good shape and that if any repeated errors can be caught so that your staff can be properly trained. And all of that work can be protected under attorney client privilege, which is something that you do not get if you just use a regular auditing support company. Um, Also, if your company has scaled really quickly, this is something to be aware of as you're building operations, ensuring that I-9 compliance is a priority. If you're onboarding a lot of employees remotely, that's also an area where there can be a lot of I-9 compliance issues. Or if your HR is running across multiple states and locations, those are some other risk profiles that ICE will look at. So again, it doesn't matter what industry you're in, it's more about how the company could potentially be operating. So I hope you found this informative today. This is exactly the type of case-by-case pattern recognition that we're going to cover in the HR I-9 compliance cohort, which is launching on September 19th. And we now have our registration open. I will drop the link down in the comments. So we would love to have you. We're going to dive deep. It's 5 live sessions with me with Q&A afterwards. There's a whole bunch of downloadable resources that you can take with you back to your day-to-day operations and start using right away. You'll have access to all the recordings for 90 days, and then you get a certificate of completion at the end, which you can then submit to SHRM or HRCI for educational credits. And the program is designed for you to get 5 educational credits. So definitely check that out. DM me if you have any questions about it. I'd be happy to give you more information. But again, my name is Emily Brown, founder and principal attorney of Elevate Justice U.S. Immigration Law. Thank you for joining me, and I will see you next Wednesday, same time, same place. Have a great week, everybody.